Hi, I'm Amanda Jacinto from Bow River Law, an employment law firm here in Calgary. Today, I'm going to be discussing a blog post on Bow River Law's website titled, I Know What You Did Over Your Lunch Break. Now, this blog was drafted by myself and it was posted on our website on February 6th of 2023. Now, this blog post is a summary of the following case: miscellaneous employees, Teamsters Local Union number 987 of Alberta versus Sobeys Capital Incorporated, Rocky View, 2023, Canley, 4464 ABGAA. Now, this at the time, it was a recent Alberta labor arbitration decision involving a grievance filed by Sobeys employees in relation to surveillance cameras that were installed in the lunchroom, where approximately 300 employees often took their breaks. Now, the union argued that the employees' expectation of privacy in the workplace outweighed Sobeys' justifications for cameras in the lunchroom. Now, the facts of this case are as follows. Sobeys installed cameras in the lunchroom. Now, this wasn't a rare practice for Sobeys. Throughout the entire facility, there were cameras installed. However, the employees took issues with the ones that were specifically in the lunchroom. Now, these cameras were not hidden from employees. They were in plain sight. There was signage warning employees that there were cameras and that they were being recorded 24/7. And the employers had a policy in relation to the use of the cameras. For instance, it was used as a deterrence method. It was there to protect the safety of staff, assist law enforcement, and there are only particular individuals and circumstances when these videos could be reviewed if it was deemed necessary. The employer also held on to the videos for approximately 4 to 5 months. Now, the employees were aware of these policies or had the ability to get access to these policies as well. So the union did argue ultimately that less intrusive measures could be used instead of video cameras in the lunchroom. However, the employers argued cameras were required. Now, there weren't many instances of events happening in the lunchroom. There was, I believe, one instance where there had been an argument. However, the employer took the proactive approach in installing cameras in the lunchroom just in case anything were to happen in the future. Now, the arbitrator in this case said in such situations such as the present one in this matter, the test of reasonableness in all the circumstances is to be applied, which requires a contextual and reasonable balance of interests. Now, the arbitrator ultimately denied the grievance and allowed the employer to continue to have the video cameras in the lunchroom. Now, the arbitrator did list multiple factors that impacted his decision, such as the following. The cameras were obvious to the employees. Sobeys the employer drew their attention to them during orientations. There was signage. So they weren't surprised that there were cameras in the room. They were well aware. Another factor that was taken into consideration was the employer's commitment to maintain a safe work environment. This also applied to the lunchroom. The arbitrator also discussed that there is case law that states that employers are to take proactive measures in protecting the workplace, right? Like they don't have to wait for an incident to occur to install cameras, so they can be proactive rather than reactive. And the arbitrator also found that the policy was clear. There was rules as to proper use of the cameras, improper use of the cameras, and how they were going to use recordings, for instance. And again, only a limited amount of employees had access to the videos, like I had mentioned earlier, 4 to 5 months. Now, the arbitrator did recognize that the union and the employees were concerned about the use of the videos and what Sobeys would do with them. So the arbitrator did advise the employer that they should take steps to ensure that the employees were aware of the surveillance cameras in the lunchroom and educate them further on the policy. Despite it being found that they were aware of the cameras, the arbitrator held that the employer should take an extra step in informing the employees as to what why they were there and what they were being used for and when they would be used. Now, my take on this is it's not an easy task to balance the privacy of individuals against an employer. Employers do have a duty to provide a safe workplace. So there needs, again, a balance needs to be struck. However, when employers are taking such steps, such as, let's say, recording in the workplace, they should ensure that employees are aware that this is going on. For instance, the cameras, draw their attention to the cameras, ensure that the employees are aware of the policies surrounding the use, because again, you are being recorded and could be private, right? You're having lunch in the lunchroom. So it's of utmost importance to ensure that everyone is well educated in what's going on in the workplace. Now, I think if Sobeys had demonstrated that there are already problems in the lunchroom, it probably would have been harder to justify, but that's just my take on it. Now, if you would like to take a look at this blog post, just head over to Bow River Law's website, click on the blog tab, and you'll find it there.